Great. So, so my name is Andrew Paley. She just said, I am a PhD candidate at Northwestern University. I work in the C3 lab, and I'm here today to talk to you about our paper, From Data to Information, Automating Data Science to Explore the US Court System. So the important thing here is, sorry, I'm having a bit of a technical thing. One moment. So to frame this, to step back and put a frame on this whole thing, the U.S. federal court system might feel like a monolith, and it might it might seem like one massive unit, but in fact, it's a tapestry of countless unique decisions made by individuals across hundreds of thousands of cases filed annually, as those cases work their way through 94 district courts, 13 circuit courts, and on up to the Supreme Court. To get an understanding of what's actually happening in this court system, we have to actually be able to answer a series of questions. And those questions, and there are a lot of those questions, they include how often are fee waivers granted? Does it differ by district or case type? Do judges treat parties differently if they're self-represented, if they don't have legal representation? Do cases take longer in some districts versus others? Does that change by case type? Do judges nominated by different parties behave differently? And has any of this changed over time? And getting to the answers to these types of questions from the raw data produced by that massive system is in some part a technology problem, but it's also a problem of understanding domain. It's a problem of understanding the questions to ask. So the work we're doing and the work that you present in this paper is actually part of a broader initiative called SCALES. And SCALES is composed of about 24 individuals working across law, computer science, journalism, and social science at a host of different US institutions. And they're all working towards, we're all working collectively towards this one goal, which is to bring transparency to the systems and processes of the US courts, ensuring that they are fair, efficient, and accurate. There are different parts of this problem, and different groups within SCALES are working on different pieces of it. But the one we care about and what's covered in our paper is how we go from the data, the information created by that system, to the answers to those questions I presented a moment ago. Now, when we talk about data from the US court system, we have to at least note PACER. So the PACER system, the Public Access to Court Electronic Record System, is paywalled. So this is how we get access to public records, the court records, but they cost money. It's 10 cents per page, maxed out at $3 per document. The result, in effect, is that analysis at a system level is prohibitively expensive. If you care about one case or 10 cases, getting the documents associated with that is not a big deal. You start to do system level analysis across tens of thousands, hundreds of thousands of cases, and it becomes too expensive to bear in most cases. That is not the focus of the work we do in this paper, but it is something that the broader SCALES initiative is focused on. How are we getting access to the data from all the different districts, and also tracking pending legislation that's working through Congress to address this problem. But let's say we had the data. So let's imagine a world where all that data was actually available. You know, there's a version where we can sort of high five and we go home and we're happy with the fact that we made the documents free and we put them online. And that is a reasonable end state for a lot of open data initiatives. You know, this is sort of the put it all online, let someone else sort it out approach to information access. And I don't think it's hard to imagine that if you went to someone who cared deeply about the court system, about justice in the United States, say a legal scholar, a lawyer, a journalist, and you handed them millions of documents and they wanted to understand something about the system broadly, they might feel like that's a relatively opaque form of transparency. So this is where the work that we cover in our paper actually starts. And so the big idea here is there's two hops in our paper. There's two tracks. One hop is from documents to structured data. And that is, that's what we cover here. And the other hop is how we get from data to the answers to those questions. But documents to structured data, what are we starting from? We're starting from 270,000 case documents, case dockets, excuse me. If you're not familiar with what those look like in the US, that's really just the overview of a case. So that's the district, the name of the case, the judge or judges, the parties, the type of suit, criminal or civil, the nature of suit, if it's civil, who are the lawyers involved, if the case is finished, what was the date terminated, and what was the outcome. And in between, the docket entries trace all of the events within a case. And those are unstructured text. Those are hand entered by people. They're different across districts. They can be different based on just the clerk entering them. So how do we go from that to structured data? A database of 25 to 30 tables. Takes extraction. We have to pull those HTML documents apart. It takes enrichment. So we're deriving a bunch of additional data points. The simplest example of that is case duration, where if the case has finished, we have a date filed, we have a date terminated, and on the way in, we're deriving, the length of the case in days and storing that. There's a host of other features we're deriving like that. It includes language modeling. And by the way, all of this is covered in more depth in the paper, so there's plenty of details to dig into there if you're interested. The language modeling component, as we talk about in the paper, we're using to classify docket entries. So the early experiments are related to motions. We want to be able to track, if a docket entry is a motion, and then it's a motion of what type. From here, the ongoing work is classifying other types of docket entries. So orders, one example, responses to motions, case outcomes. And so that work rolls forward. Sort of implied by that is the notion that we are ontologizing cases, right? We're trying to get to the right layer of abstraction such that we know what tags to generate, what types of features to look for, so that we can create sort of the overall map, the contour of a case for the sake of case comparison. So this work is one thread under the scales banner. Like I said, the details are included in more depth in the paper. And it's the hop from documents to structured data. Now, there's a version of the world where we say, great, now we're done, right? We've done the work up front to go from these unstructured or semi-structured, this raw data, and brought it into structure. We've done the world a service, and we put that online, and people can now come and get the information out as they see fit. That step of getting the information out as they see fit, of course, takes one of two things. It takes skills or it takes resources. So skills, you want to make use of 25 to 30 tables with millions of entries. You need to know how to write code, create SQL queries, generate visualizations, possibly work with language models, etc. Or you need resources. You need to be able to hire someone that has those skills. This is like, data scientists as the human interface, or graduate students in some cases. So if you don't have skills or resources, then, if you're a journalist or a legal scholar who actually wants to understand that data, to ask questions, to get the answers to the questions we looked at up top, then we get to a place where, open data is actually necessary but insufficient. And this is true broadly. So we're talking about US federal court data right now, but any open data, open government initiative that stops at, we've put the data online somewhere, now you go figure it out, is sort of half the battle. And what we really want is open information. And this is really what we mean when we say open data. It's sort of a proxy, but it's a halfway. So how do we bridge this gap then? How do we go from structured data to information? Well, what we're getting into then, just like the title of the paper suggests, is automating data science. And the goal for this second track of work we cover in the paper is that we want to empower non-technical users with the tool set necessary to drive data search and analysis without a data scientist in the loop. How do we do that, right? And that's what we'll be talking about through the rest of this paper now, for this presentation. Well, if we want to automate data science, we have to understand what data scientists do. And we're sort of rolling it up to 3 high-level buckets. No offense to any data scientists in the audience. Of course, there's a lot more to it than this. But the sort of interaction pattern starts from when a domain expert enlists a data scientist to dig into data, the data scientist needs to take stock of what's available and surface the space of the possible back to that domain expert. This is the data we have on hand. This is what we can do with it. They then can listen, have conversations with the domain expert, and translate the information needs, the questions, back to queries and analytics. And then when an answer is arrived at, bring that answer back and communicate it in a way that's clear to the domain expert. So if we want to automate that, if we're trying to build a platform that fills that role, we need a system that doesn't remove the complexity of data science or data analysis. It instead puts as much of the burden as possible on the machine. That is the Satyrn platform. That's what we're building in the C3 lab. We don't name it in the paper. We discuss it in detail, the version 1 of it. But the name we've given it is now Satyrn. So the scales application, the demo I'm about to show you in a moment, is an instance of Satyrn. And we'll dig into the particulars during the demo, but the things to take away at this level, looking at this bird's eye view, is that the user experience is what we call a natural language notebook. You might get the Riff from Jupyter Notebooks if you're familiar with them. We're borrowing from the paradigms of data science tools, but instead of saying the inputs are code, we're saying those modular steps, that sequential data exploration, is now supported by simplified filters and plain natural language statements. The other thing to note as we go into this is that the system itself has nothing about any domain or data set hard-coded in it. The query generation, the analysis engine, the search components, the API, and the front end, nothing about a particular data set. That's brought to the system through an ORM layer and an ontology configuration. I don't have time in the presentation to go deep on this. We cover the V1 in the paper. But the long and short of it is, we need that specification of the database, the ORM, the list of tables and fields, and we need a little bit of metadata on top in V1. And this is stuff that abstracts away the schema and brings it closer to the mental model of a domain expert, someone who's asking questions, right? So this is stuff as simple as, it's not 3 or 4 fields that are strings in a particular table, it's a judge's name and they have a relationship to a case. So when a user says, I want to search by judge's name, they're not thinking about the particulars of the joins and the underlying fields, they're just entering some text and the system takes care of it. This also includes stuff like, it's not just a float, it's a case duration and it's measured in days. So where we're headed in V2 is collapsing this all down into a much simpler representation that looks a lot more like a standardized ontology with entities and attributes and relationships and a hierarchy. And that part is not in the paper. That's a matter of future work, but we're really excited about where we're headed with it. So demo, I'm gonna jump out of this and move my share over. Okay. So I trust at this point you are seeing a web browser and someone shout if not. So what we're looking at now is a Satyrn notebook. It's an instance though of the Scales platform. So the data that's loaded in is the data we've been talking about, right? This is case, these are case dockets. So if I open any of these up, I can dig around in the actual data of an individual case. But we want to support that, but what we care about most is asking questions across the whole data set. So let's collapse that data view. There are 267,000 dockets loaded in there, and I'm going to add a filter. The filters are, again, derived up from that layer of data semantics on top of the database. I'm going to say district, I want to look at the Northern District of Illinois. It's where I'm from, but also it's where we have the most data currently. So I make a selection and the filter updates. So now I'm looking at, now my data context has 104,000 case dockets in it. Let's ask some questions. So I'm going to add some analysis. The system asks, what do I want to know about? In the current iteration of the platform, we're presenting this as a sort of search or select dropdown, but it's, as you can see, it's not a great browsing experience. These statements are all the permutations of analysis that the system knows it can do, that it has inferred from states in the data, as well as what it knows its core analytics engine is capable of. So it's better to search than to browse. So I'll search for duration, and let's find out how long cases take in the Northern District of Illinois. So on average, they take 348 days. That's a really quick response to, search across or analysis across 104,000 cases. I can find out a little bit more if I want, a description of that metric, how it was derived, which again is pulled up from the underlying representation, and the data validation details. So the system will tell me, hey, you wanted to run analysis across 104,000 cases, but 6,000 of them actually didn't have a value that I could run an aggregation on, so I omitted them. We're still looking at an average across 95% of the data. And by the way, in terms of average case duration, that's just because the case hasn't ended yet. So we don't have a duration calculated. So now I might want to say, I want to know about that over time. How has duration changed year over year? Oh, I'll spell year right. I'll make a selection, and this time the system will respond with a line chart. And this is because it understands when I'm talking about something over time, a good way to present it is line chart. If I'm talking about a distribution, a good way to present it is bar chart, and so on. So now I've answered a couple questions. I get a sense of how case duration has changed year over year, a little interactive chart. And now I decide I want to drill in more. So I can add a second filter. This time I want to look at cases with a nature of suit related to intellectual property. So I'll select that.
Paley, just 3 minutes last.
Yeah, I got 2 or 3 minutes and I'll be done. Oop. So property rights, that's what I wanted to search. So nature of suit, property rights, which I know is tied to intellectual property. And note that from that data context updating at the top, the questions below now update. So now with that additional filter, we see that cases go much faster when they're related to property rights. And interestingly, we see they sped up, right? And so from here, I might want to ask a whole bunch of follow-on questions. For the sake of time, I'm only going to ask one more. I might want to know about caseload per judge, right? And I could ask that question directly, but I could also break that caseload picture down by different dimensions. And so I will do cases per judge year over year, broken down by judge tenure. Let's see where that is. Cases per judge, group per judge tenure. Here we go. And so now I get a much sort of deeper portrait of the analysis. And I see that actually right about when those cases were speeding up, as I can see from this particular chart, that's when a whole bunch of brand new judges who had been on the bench less than 5 years, started to actually get those cases. So I can't go much further, but what I hope this is giving you is a sense that I'm able to explore the data very flexibly, apply filters, and ask a whole bunch of different questions in this notebook format without knowing code, without knowing SQL. And so just to wrap up, early results are looking promising. I trust you can see the slides again. Early results are looking promising.
Slides. Yes, we can see the slides.
Cool. Preliminary user testing across 15 subjects. We're actually in a second round of user testing now, but the first round, we had people complete tasks within the system. They came back, they filled out a survey. We got high ratings on usability. We got a 73 sus score, which is considered good usability. We detail these results more in the paper, and 87% responded that they would use the system frequently. Future work, there's a track of work on the data that involves more language modeling, more data enrichment, and blending of additional sources for court records. including state courts, Supreme Court data, and then other sources like census data. And then future work on the platform involves expanding the analytics, refining the user experience, multi-data set exploration in one view, bringing new data sets through the UI, and a whole bunch of interesting things that flow out of that. In-platform language modeling, language model training, which we'll get into in future publications, as well as expanding the purview. So we're bringing this to political data right now. We're looking at bringing it to education-related data and alternative user experiences. And so on behalf of the team on the paper, I want to say thanks, and I want to acknowledge the National Science Foundation for supporting some of this work.
Okay, great. Thank you, Professor Andrew Paley, for your great presentation. The first question that we have is that this system is available for testing.
We're actually working towards an open
for
beta.
a researcher from another country.
Yeah, so we're working towards an open beta, and I would encourage you. I flashed my email address right there at the end briefly. Oh, can you hear me? So we're working towards an open beta. I had my email address on the screen briefly at the end there, and I invite anyone to reach out to me. We hope by later this year to invite more users to take advantage of the platform in an open beta.
Okay, great. I think they will be anxious to use it. And the other question that we have is, in the paper, specifically in the future work section, what is the author opinion in the cited transparency in the US court system as a database of the proposed model? And what would be a rebound if the US courts decides in the short future to enter into an opacity instead of the stated transparency? Did you understand?
I heard most of that. I think so. Is the question related to whether you know, if the courts were uncomfortable with this level of transparency? Oh, I see you added in the chat. Great, thank you.
Yeah.
Okay. So if the truth of the matter is that because of the way the data is, the way that the system is set up, court records are deemed public records. So the friction associated with the paywall is friction, but legally speaking, the court generates, as a part of our government, generates public records. So they can't prevent us entirely from having access. They can add friction to it. So that being said, there is an open question as we bring more transparency to the court system of how that will be perceived, and that is a conversation happening with the broader scales team. But we hope that is a positive thing across the board, that people realize that more engagement, more civic understanding is actually a net positive, regardless where you are in the system. I think we're having some technical difficulties, but I hope you all heard that answer.
Yeah, I have some technologies. So sorry, I couldn't hear. If you could repeat the last part of your answer, if you don't mind.
I was just, oh, sure. I was just saying that they are in fact public records, and we hope that what the work we're doing is recognized as a net positive across the board by all members of the system. You know, that transparency is a good thing, civic engagement is a good thing, that this is, after all, a democratic country, and we hope that the transparency is not seen as a threat, that we hope it's seen as a net positive.
Okay. Do you have any action plan to continue to be transparent and to avoid the opacity? Or do you believe that your model is already transparent?
So to avoid opacity, sorry. So do you mean like in our platform, once we have the data?
Yes.
Do you mean, okay. So providing the data very well could be part of the broader scales initiative. What I'm talking about is the platform that helps people take advantage of it. But absolutely, you know, downloading the data directly, if people want to get their hands on it, that is part of the broader roadmap, getting access to just the raw data, if that's the nature of the question. I'm sorry, I misunderstood.
First one. Actually, before asking, I have to say something. This kind of tool that you develop, I think it's very important to improve access to justice, and not only to resolve conflicts, actually also to achieve what Richard Susskind says, like promoting people's legal health, you know, because you can empower people about their rights, not only about conflict and how to resolve it. So very good, congratulations. So let's go.
Thank you. Thanks very much.
So how does your system handle personal data, especially sensitive personal data, presenting legal documents? Is this a cause for concern?
That's a really great question. So interestingly, these records are already public, right? This is public data already. But the fact that there's a friction to access, that they're not easily sort of accessible, provides some sort of obscurity. So oddly, as I've dug into this issue, there's not a lot of sort of best practice here. And so in that broader scales group I talked about, we actually have a working group digging into this privacy issue, because we know it's a real issue, and we want to honor the fact that we have a responsibility here. But finding the line between sort of public information, like public interest, versus privacy is a little murky, right? On one hand, it's obvious that there are individuals that show up in some of these court records. I'm trying to come up with, let's say Donald Trump shows up in a case. We wouldn't want to de-identify him because there's a public interest in his involvement in a case. That being said, on the other end of the spectrum, there's obviously a whole number of private individuals involved in certain cases that we absolutely feel the need to de-identify. And we're working on finding out that gray area in between, where the line is, such that we can implement a solution there. So this is all a long way to say, in the current iteration, we have not actually implemented de-identification, but we are absolutely tracking that it's an issue, and we have to figure out what level we want to go to, and that's part of the broader scales work.
Okay, good. The second one, what are the biggest challenges involved in transforming raw data extracted from documents into machine-readable content?
So yeah, structuring that documents to data hop, there's a number of things there. Court records are human-generated data. So, you know, court clerks are putting that stuff in, and they're not thinking about, the system is not designed for analysis at scale. It's designed for, I'm just going to sit down and write out, you know, what was just said, what the judge decided, times a million. So the dockets themselves, there are lots of filing errors. There are things to sort of deal with at a document structure level. And then when we get into the actual docket entries, there's an enormous amount of variance that you know, the same thing in two different districts will be expressed different ways. And so again, there's this working group, there's an ontology sort of working group that is really just trying to come to the right sorts of abstractions, so that when we come up with an ontology of motions, it covers cases as they happen, you know, in Georgia and Washington State, that we sort of have the right abstraction level to capture everything. So yeah, I think it's dealing with human scale data, and that is from the docket itself all the way down to individual docket entries, and it's coming to the right sorts of abstractions across all of the things that can happen in the proceedings of a given case.
Okay, another question. Does your model include prediction of decisions?
So yeah, predictive, sort of like judicial predictive analytics. At this point, no, and we've actually decided to sort of circumvent that, at least for the time being, because we're much more interested at this stage in surfacing what's happening, right? I mean, it's more of at this stage, more of a journalistic pursuit. Understanding what's going on in this massive system is the primary focus, and less so on trying to game the system, trying to figure out a prediction for a given case, because that invites attempts to game the system. And so we're not starting there. And I think in this particular project we will not head there.
Okay, thank you very much, Mr. Andrew Paley. Do you have any final comments?
No, other than just thanks a lot for having us. I'm really excited to be here at the conference, and I appreciate you saying that at the beginning about the nature of the work. We're really excited about this. I think we think it's important work, and we have a lot to do ahead of us. There's a lot coming. But I really appreciate the venue, the opportunity to speak.